Welcome to Huddleston Bolen. Today we'll be featuring Scott Sheets, a partner in the firm's Huntington, West Virginia office. Scott's practice is focused on employment law and labor management relations. The focus of today's presentation is a sexually hostile work environment.
Sexually hostile work environments don't necessarily have to include sexual interest. A lot of employers assume that in order to have a hostile work environment, there has to be some sort of sexual interest or sexual desire at work. Not necessarily. Courts have been cracking down on employers that allow their employment work setting to turn into horseplay settings. Two recent case decisions underscore this, and I'd like to talk about each one of them. The first one is EEOC versus Bow Brothers Construction Company. This is a case from a rather conservative area of the country, Texas. It's a United States Court of Appeals decision. And in that decision, the court laid out the facts of the case and explained why they found that there were sufficient facts for a jury to decide whether or not a sexually hostile work environment had been created. We had an all-male work environment, construction setting. You would think, how in the world could there be sexual harassment if it's all male? Well, you had a supervisor who targeted a particular male employee and began calling him very derogatory names, having a homosexual type reference to them, simulating sexual intercourse when coming up behind him to do so, and the employee had had enough of it. He went to the employer and complained in detail. The employer undertook a cursory investigation but took no real corrective action. What happened ultimately was the employee was terminated for a minor rules infraction that had nothing to do with the circumstances. He then filed a complaint with the EEOC that he had been the victim of sexual harassment. The court agreed that there were sufficient circumstances to allow a jury to decide whether or not sexual harassment had occurred and a sexually hostile work environment had been created. The court noted that the supervisor had admitted in a deposition that he didn't think the male subordinate was manly enough. In other words, he stereotyped based upon gender. He made certain assumptions, and the employer technically backed him up, that the man didn't act in the way that the supervisor assumed male employees should act, and therefore targeted him. The court said you discriminated against him on the basis of his sex, and therefore the question of whether these acts that were committed were sufficiently severe and pervasive enough to alter the terms of his working conditions and create a sexually hostile work environment was something that a jury could decide. In another case, Barrows versus Seneca Foods, a case from the Second Circuit Court of Appeals, which is in New York, the court there was equally unimpressed with the employer's attempt to dismiss what happened as mere horseplay. There, the male supervisor called the male subordinate sexually derogatory names, punched the subordinate in the groin area, and generally created a very hostile work environment for him. There was no sexual interest at all between the two participants. It was merely the language and the physical hitting at stake. Second Circuit Court of Appeals, as did the Fifth Circuit in the earlier case, said this is sufficient for a jury to decide whether or not a sexually hostile work environment has been created. So the message for employers from these types of cases, these horseplay cases, is you need to take control of your work environment, even if there's no sexual interest at all between the person committing the acts and the recipient of the acts. You need to have your policy written in such a way that employees understand that any type of hostile work environment is going to be taken seriously by you as the employer, that you're going to investigate the same, and that you're going to take appropriate corrective action. Because the end result is clear. If you don't do these things, you're going to wind up being the recipient of a same-sex sexual harassment lawsuit, as in these examples.
Thank you for joining us for this informative video. Please don't hesitate to contact us at Huddleston Bolen for more information or to discuss your legal needs.